Supreme Court of the State of South Dakota, the Honorable Chief Justice David Gilbertson presiding, is now in session.
Please be seated. Good morning and welcome to the October term of the South Dakota Supreme Court held here at the University of South Dakota School of Law. It's always a pleasure for the court to return here. We enjoy the opportunity to have direct contact with the students, although this time it might be a little more limited than traditionally it's been, and also with the faculty and the administration. The first case for oral argument this morning is Lisa TAMMEN appellant versus Randall Jurgens appellee and the City of Pierre and the Pierre Volunteer Fire Department appellees. For the appellant, we have Mr. Mark Hay, who I understand will be speaking for 10 minutes. Okay, and then Mr. John Hughes, both attorneys from Sioux Falls, you'll be for 10 minutes.
Yes.
Okay, and then for the City of Pierre, we have Mr. Robert Anderson, an attorney from Pierre, and you'll be speaking, I understand, for 10 minutes.
Yes, Your Honor.
Okay, and then Mr. Mike Lewis, an attorney from Sioux Falls, and you'll be speaking for 10 minutes. And then Mr. Hay, you'll do the rebuttal. Is that correct? All right. With that, you may proceed, Mr. Hay, or Mr. Hughes, you're going first?
Yes.
Okay, very good. You have 10 minutes, sir.
Thank you.
Good morning.
Good morning.
Mr. Chief Justice, Your Honors.
Ladies and gentlemen,
I am John Hughes, counsel for Randall Jurgens, who together with Lisa TAMMEN are the plaintiffs and co-appellants in this appeal. I will address the issues of standard of review and the principles applicable to scope of employment, address the issues of insurance, governmental immunity, and public policy. This appeal follows the trial court's grant of summary judgment in favor of the city and the fire department, dismissing Randall and Lisa's respondeat superior claims for the wrongful acts of their employee and agent, 19-year-old firefighter Garrett TRONVOLD. I want to commend the authors of the synopsis of the case. It's excellent. Saves me time going through some facts that I would have otherwise gone through. I want to make a couple of clarifications. The first is that the automobile property damage coverage is rather central to our case in that Continental Western provided and the city paid for property damage coverage and deductible reimbursement for an employee's personal auto.
Excuse me a minute, counsel.
Yes, sir.
I hate to interrupt. Shirley, are the lights working?
Yes.
Because mine aren't. Oh. Nothing.
Yes.
Okay.
we just have to import that mine works.
Then we give you a 2-minute warning. I'll ask the clerk to do that, and then also tell the council when the time is up because mine don't work. Oh, I'm sorry for the interruption.
No problem. No problem, Your Honor. I wanted to point out that the property damage coverage and deductible reimbursement that was provided to Mr. TRONVOLD through an employee's personal auto coverage benefit provided by Continental Western, which was paid for by the City of Pierre, covered Mr. TRONVOLD while he was en route to, during, or returning from any official duty authorized by you. And in the policy, it's defined, you is defined as the City of Pierre Fire Department. So that's important with respect to the dual purpose test and the inducement to drive a personal auto, which I will get into in the case. The other comment I wanted to make about the synopsis is that way at the bottom, 5 lines up, the word commute is used. And in fact, the trial court did use commute in the memorandum of opinion. And that's
this accident occurred outside the city limits of Pierre. Is that any significance? Is that part of their fire district?
no, Your Honor.
It's not?
I'm sorry.
I'm asking, he was driving from his home to a meeting in Pierre. This is the Pierre Fire Department. Where the accident occurred, was that part of the Pierre Fire District?
Very interesting. The corporate limits of the city of Pierre is not where the crash occurred, Your Honor. The intersection of Grey Goose Road.
I know where it's at. I live in Pierre, but I'm just asking, is that part of the Pierre Fire District?
No, actually, well, that brings up a couple of questions, Your Honor. In order to be a firefighter, according to the bylaws of the fire department, a firefighter must either work full-time in the city of Pierre or live within 3.5 miles of the corporate limits of Pierre. The duty of the fire department is to suppress fires and respond to emergencies and incidents within the corporate limits of the city of Pierre. But Mr. Tronvold clearly met one of the foundational tests, which is having a full-time job in the city of Pierre. That issue will also be important to nexus and foreseeability. Because Mr. Tronvold's rural residence was located more than 10 miles from the fire station to which he was assigned. So the significance for purposes of respondeat superior in scope of employment is that the fire department provided an insurance benefit for Mr. Tronvold to drive his personally owned vehicle from a location in rural Pierre, more than 10 miles from his duty station, when he had just completed a full day at a full-time job in the city of Pierre. So we have this 19-year-old, as 19-year-olds are, driving back and forth, mismanaging their time. We believe that goes to foreseeability.
So you're saying that there was insurance coverage even though Mr. Tronvold, the site of the accident, was outside of the Pierre Fire District?
That's correct. Not only outside of the city limits of Sioux Falls, Your Honor, but he was paid for a deductible that he never incurred. He never paid to repair his pickup. And the fire department helped him process that claim with Continental Western, and it was paid regardless of his fault. He clearly was at fault in causing this crash, Your Honor.
Counsel, why should we deliberately allocate the risk of negligent driving accidents to volunteer members on their way to a meeting? I mean, you're basically arguing enterprise theory.
Well,
and
appreciate the question. It really goes to the heart of this case because the trial court ignored undisputed testimony from the fire chief that when a firefighter drives his personal vehicle to a meeting, he's conferring a benefit on the fire department and the city. Really, we're dealing with two entities here. We're dealing with the city and the fire department, which basically are a singular entity. But the point is that he's given an inducement. He's allowed to reside more than 10 miles away from his duty station because he meets the full-time work in Sioux Falls test, and he's carrying his personal protective equipment, which is everything a fire needs for his turnout gear. He's got to wear that in order to respond to an incident or a fire. He's got to have that turnout gear with him. The fire chief testified that Mr. Tronvold stowing the gear in his pickup was typical of firefighters. Below, the defendants argued that, well, the captain could have given Mr. Tronvold permission to stow his gear at the station. But think about this under the facts of the case. Tronvold is living at his rural residence more than 10 miles from his duty station. He gets an emergency call. What's he going to do? Drive more than 10 miles to the fire station, pick up his gear, then put it in his pickup, and then drive to the scene? Well, by that time, he's not going to be in a position to be an effective firefighter because the fires are burning, the people are injured. And so this is really an incredibly serious set of circumstances that we're dealing with in terms of protecting the public health, lives, safety, and property.
Mr. Hughes, I'm sorry if I can interrupt.
Yes, sir.
You say the record indicates, and I know what you're referring to, that Mr. Tronvold conferred a benefit upon the city or the fire department or both. How is that fundamentally different from any other benefit that an employee or volunteer or whomever confers when they just show up?
Well, that's a great question, Your Honor. The fire chief again testified. See, this is undisputed factual testimony in the record that the trial court ignored. There's undisputed testimony that an ordinance of the city of Pierre required Mr. Tronvold and all firefighters to attend all drills and meetings of their engine company. No exceptions. The fire department testified that, well, we don't do that anymore. It's outdated. We don't have to follow the ordinance. Well, it's an ordinance. It's undisputed that requirement exists. And furthermore, the city of Pierre by ordinance has a mandatory dismissal policy for any firefighter that misses more than 3 drills or meetings that are unexcused. So what we have here is a fire department that is out of compliance with the city of Pierre municipal ordinances that have declared what the essential protection of the public health, safety, and property is. And that duty was abrogated by the fire department.
So is that the distinction that you're making? Because it seems to me like any other employer, private, public, or whomever, might have a similar attendance policy that says, you need to show up to work. We kind of expect you to be here.
Your Honor, we need to look at the nature of the activity, which is an essential.
That's what I was saying. Is that the crucial, is that what your argument is?
That crucial. Mr. Tronvold has his pager with him, he has his gear with him, he has a half plate that says member fire department, peer fire department. It's foreseeable that a 19-year-old, lacking situational awareness, mismanaging his time, completing a full day of work at Morris Equipment and Pier, driving all the way home, relaxing for 45 minutes, whatever that is in a hurry. 6 p.m. on Monday, August 1, the heavy traffic that, I know Your Honor, so we're all familiar with Pier, and I am to a lesser degree. Grey Goose Road and Highway 1804 is abuzz with traffic at 6 p.m. Tronvold is 19. I've raised 3 boys. I know how long it takes for the frontal cortex to develop in a young man, as distinguished from a young woman. He's in a hurry. He's related to the assistant fire chief. He's got his half plate. He's in a hurry. He's got his 3/4 ton pickup. He's going to get to that meeting on time. He's going to speed, and he did.
Mr. Hughes, we've said scope of employment is generally a question of fact. But then we get to the narrower question here of is the going and coming rule. So if the employee is going or coming to work, is that a question of law, and does that resolve it?
I'm so glad you asked that. You know, Your Honors, there have been 6 cases since 1963 that have applied the going and coming rule. I'm not aware of any of them that established liability. They're all raised in a workers' compensation context, and Justice Konenkamp did a great job explaining in South Dakota Public Entity Pool for Liability versus Winger that this court resorts to workers' compensation because they're useful, but the legal precepts surrounding respondeat superior are contained in the restatement, sections 228, 229, leaf green. There's a whole series of cases that we asked the trial court to apply, and the trial court didn't. The trial court merely concluded, well, you couldn't foresee that.
Your time has expired, counsel. Thank you.
Thank you, Mr. Chief Justice, Your Honors.
Mr. Hay, you have 10 minutes, sir.
Thank you, Your Honor. May it please the court, counsel, ladies and gentlemen. That 10 minutes went fast, so I'm going to skip most of my peremptory stuff and get right to the point, which I think you were asking Mr. Hughes about. There's a lot of cases you've seen in our briefs that go either way on this question of, is there going to be a required vehicle exception to the going and coming rule? And I think, regardless of what case you look at, for the most part, they look at 2 things. And I think those are key for this court to look at. And I agree that it is a factual question, but they look at benefit and they look at control. In other words, with regard to benefit, is the benefit to the employer such that it's fair to impart liability on the employer as a cost of doing business? Is the employee benefiting from the use of the employee, or in this case, volunteer's vehicle? In this case, the answer
Is there a distinction between a volunteer and an employee? Because clearly, in those kinds of cases, clearly they're employees.
not in this case, Your Honor. I think South Dakota law clearly states that if a volunteer is acting in furtherance of an entity, that their negligence can be imputed to the entity. So we're narrowing it down to the required vehicle exception. We don't dispute that in a typical circumstance, the employer is not liable when the employee is driving to work. But in this case, we have a lot of distinctions. So back to the benefit portion, clearly the Pier Fire Department benefits by requiring Mr. Tronvold to have his own vehicle to respond to fires.
How is it distinguishable from any other employer requiring their employee to arrive at work on time?
Well, my son asked me that on the way down here to the argument, and I said, that's a very good question. He said, what about the fact that sometimes I have to go to a deposition? Does that mean when I'm going to work, because I have to have my own car, that every time I'm in an accident driving to work that I'm under this exception? And the clear answer to that is no. This isn't this isn't a case that's going to open up the entire world of if you're driving to work and you get in an accident just because you might have to have your car there for some incidental portion of your work that you're liable. In this case, there's several distinctions. First and most important, they require, as a requirement to this job, or at least there's a question of fact, the fire chief said it was a requirement of the job, that you have a fire, that you have your own vehicle so you can respond to fires. It's not an incidental part of the job, like maybe if there's a deposition, I have to drive my car to the deposition. This is a specific and instrumental part of the job. I need this car to respond to fires. 3, Mr. Tronvold, as a volunteer fireman, is on call at all times. If Tyler's going to the grocery store, or if he's driving to work, he's not going to get a call all of a sudden that there's an emergency deposition. In this case, Mr. Tronvold, this is different because Mr. Tronvold actually has to have this vehicle to respond to a fire, which is an integral part of his job. And third, as Mr. Hughes pointed out, he identifies himself as a pure volunteer fire department, but most importantly, in this particular case, he was transporting his personal protective equipment to the fire hall, the property of the pure volunteer fire department, to the fire hall in order to conduct training. And he needed that personal protective equipment in order to accomplish the training.
Mr. Haig, do you see some distinction between had he been leaving to go to an emergency situation where he needed that personal protective equipment, or it would have been not practical to go 10 miles into town if the location of the fire was elsewhere? A different scenario than attendance at a regularly scheduled meeting.
I guess if I'm understanding your question right, Your Honor, I don't think there's any question that we wouldn't be here if he was going to a fire. Clearly, then, he's acting within the course and scope of his employment. It's not even a question of fact at that point. He is
Could I invite you to use the,
acting within the course and scope of
around
his
the
employment.
Thank you.
If I could move on to control, which I think is the second factor, to wrap up the benefit issue, Pierre could not have a volunteer fire department if they did not have firemen who are required to have vehicles. They need the vehicles to get to the fire. It is instrumental, it is critical to the Pierre volunteer fire department that their volunteers have vehicles.
The UJS has 550 employees. I would guess every one of them drives to work. Maybe there's one or two that walk. So what's the difference?
Because it's not an integral part of UJS.
Well, they're not going to get to work if they don't drive.
I'm sorry.
They're not going to get to work if they don't drive there.
Well, they can get to work any way they want to get to work. In this case, there's a question of fact as to whether it's practical for the fireman to get to the fire in some other conveyance, or, I mean, is he really going to say, hey, Mom, let me grab my fire equipment and take me to the job? I think we get back to that fact question. Did they have the requisite amount of control over the fireman? Which leads me to the second factor, and that is control. In this case, unlike other employers, the Pierre Volunteer Fire Department exercises control over the Pierre Volunteer Firemen. First of all, the fireman is always representing the fire department. Unlike in other jobs when you're off duty, nobody knows where you work. In this case, Mr. Tronvold was acting as a fireman, as identified on his required vehicle. I'm a fireman. And other firemen, I don't think Mr. Tronvold had a blue light, but other firemen had blue lights. He was a rookie, so I don't think he got to that point. But the volunteer firemen are identifying themselves as firemen. The volunteer fire department and City of Pierre ordinances both have control over the firemen in numerous ways. And so they can exercise that control over Mr. Tronvold when he was driving. And I think that gets back to your original question, Your Honor. One of the aspects of control that they would have is they can and they do determine where a fireman can live. So in this case, they had the right to control where Mr. Tronvold lived, and they allowed him to live 10 miles away from the fire station.
So, Mr. Haig, I'm sorry, I'm going to, if I could, talk just a little bit about this test. So the idea that you have a required vehicle, requirement for that, you have control. Is the application of that rule in this case and in the mine run of all cases lead to the same result? Or would it be a different result or even a different test if somebody lived right across the street from the fire hall. In that instance, do you think, is there a factual question, or would your rule still suggest, no, you've got to have a vehicle, even though the person could walk right across the street to respond to a call, an emergency call, and go to the fire hall? Is that requirement still a requirement? Is it a softer requirement? Is this a universal rule? Does how do we reconcile the rule that you suggest here with maybe the broader range of cases that might be out there?
I think your question answers our argument or response to our argument, and that is, it's a question of fact. The fire chief said firemen have to have a vehicle. Practically, they do. You can understand that you can't really not have a vehicle and be a pure volunteer fireman. You got equipment to take, you got to get to the fire. Okay, is there a circumstance where a guy lives across the street where he could walk over, jump on the fire truck and go to the fire? I think probably, but in this case, I think the jury gets to look at all the circumstances.
Maybe I'm mishearing it then, because I thought your argument was, no, that's the rule. You got to apply this rule. Part of this rule that you think is an exception to the going and coming rule is that they had this requirement. But was it just a requirement for Mr. Tronvold, or is it a universal requirement? Because is there an exception that would apply just to him, or would that apply to other members of the Pier Fire Department?
I think the fire chief testified that it is a rule. So,
yeah.
Again, there's a question of fact. After the fire department chief testified it was a rule, there was a significant backtracking, as you might imagine, in cases like that. But the rule the fire chief said was, yes, there was a rule. He said, we've never had a fireman, to his knowledge, that hasn't had a personal vehicle they could use in responding to fires. I guess I was responding to your question is there some circumstance you could envision where they wouldn't need it? I think the answer is yes.
Somebody's got to drive the trucks, so not everybody's driving their vehicle right to the fire.
Right. He said it's a rule, but I'm agreeing with Justice Salter that I can conceive of a fireman who could be admitted and not have one, but I think that's, again, we get back to, is it a fact question?
Are you still pursuing the special errand and dual purpose exception?
I want to say I am, but truthfully, the required vehicle exception is the better argument.
It doesn't fit. The other two don't fit as nicely with this set of facts.
If you're not going to find for us on the required vehicle, I don't think you're going to find for us on the special errand. But I do think it was a special errand, given what I talked about before, that he was on an errand to go get trained with fire department property. You want to talk about insurance?
No, I guess you won't. Your time is up. Sorry.
I'll be back. Thank you.
You will be. Thank you.
I imagine I'll open the door for him so he can talk about insurance, which he forgot to talk about the first time. It please the court, Mr. Chief Justice and Counsel. My name is Rob Anderson. I'm here for the City of Pierre. And before I go into some comments on the facts that have been discussed, what the appellants are doing in asking this court to impose liability on the City of Pierre in this case is that would really reverse years of precedent in this jurisdiction and in virtually every jurisdiction around the country under these facts. It would contradict settled law regarding respondeat superior, vicarious liability. The facts here, we submit that there's no genuine issue of any material fact which, if resolved differently, would lead to a different result other than granting summary judgment under the existing law and the facts we have. Extending liability, however, the way the appellants asked this court to do would cross the line that, as I said, the law doesn't support, but neither does common sense. I want to talk first a little bit about the control and benefit issues that Mr. Haig raised. We have to remember what Mr. Tronvold was doing at the time of the accident. And by the way, I think the record shows that it's 7 miles from his house to the fire station he reported to. He didn't report to the downtown fire station. He reported to the, I'd call it, well, I'm not sure what it's called. It's one up by Jefferson School. He lived north of town on the Grey Goose Road. He was going to a non-mandatory training. I know that there's difference in the city ordinance and the policy which the fire department acknowledged they followed, but Mr. Tronvold attended all his required trainings. And whether it was mandatory or not, he was going to the fire station for that reason. There is no evidence in the record that I read that indicates he was going to use his personal protective gear. It was vehicle training that he was going to that night. So he lives about 7 miles from the fire station. I live in the city of Pierre, about 6.5 miles from the fire station. Many people in Pierre, in the city limits, live that far. He could have taken any route he wanted to take on this accident. He didn't have to go the way he went. He could have gone over the dam and across through Fort Pierre. He could have done a lot of different things. His employer, I won't say employer, he's a volunteer. The fire department didn't control that.
Well, let me ask you this, Mr. Anderson. They're a little bit different than the typical coming and going situation where an employer says, be here at 8 o'clock. I don't care if you take the bus, walk, how you get here, just be here at 8. Mm-hmm. Here we have a situation where at least the fire chief, or, take the facts most favorable to the plaintiff, would say they had to have a vehicle because they have to be available anytime, 24 hours a day, and they have to be able to drive that vehicle. They buy property insurance for the firemen. And, does that suggest perhaps that there's some benefit that they're receiving, that the fire department's receiving? And I know you're representing the city, but that the fire department's receiving because they're paying for a property damage coverage for a personal vehicle. So those are a couple of facts that are a little bit different than your typical situation. When does it become a fact question, or when does the required vehicle exception apply? Well, and what kind of facts do you think you have to?
That's a good question, because I thought to myself as I came here, having considered everything that's been discussed, and I'm sure will be, if these facts are enough to impose liability on the city of Pierre, what isn't enough? What is going to, and if you think you won't hear hundreds and hundreds of cases in not just a fire department or governmental setting in the future, if the law that appellants advocate here is adopted, I think that's wishful thinking, because then you've created exceptions that eat up the general rule. But I didn't answer your question. The question is, all of the required vehicle cases require more than just that type of incidental benefit. Most of them refer to that as an incidental or I can't remember the other word, but they refer to it as incidental benefits. I would say these are incidental benefits. In the cases where there are even numerous cases that apply the going and coming rule strictly, that involve benefits to the employer far in excess of those that would exist here. There are people that have to use their vehicles on the job. Now, when Mr. Tronvold got to the fire hall that day, he wasn't going to use his vehicle, and there's no evidence he ever did. He did his work on a fire truck, fire engine. There's nothing here other than the incidental benefit of getting to work and being able to go home, but the elements of benefit and control do not rise to the level I would submit of any of the cases, and there are very few.
So in my example about the UJS employees I presented to opposing counsel, you're saying that if one of them drove to work, which I assume all of them do, got into an accident, potentially, under the plaintiff's theory, the UJS could be held liable.
You're going to hear arguments like that, yes, and that could be possible. On my way here yesterday, I drove by, since this is coyote country, I'll use this example. The guy who shoots coyotes from an airplane for Game Fish and Parks Department, he's got to get to the airport. I know that he doesn't have a requirement that he have a vehicle, but logic tells you he's got to have a pickup or a car to go there. Carries his guns in the back seat. When he gets there, he does his work from an airplane. Just like Mr. Tronvold did his work from a fire engine. Is he going to impose liability on the state by driving to the airport to get into an airplane? I don't think so. And I would submit that's really not any different.
Do you see a distinction with the employees or volunteers of this sort that have to respond to emergency situations as opposed to the example that you just gave? That makes the benefit of having a required vehicle be a little bit more than an incidental. I
think at times that would be true. Mm-hmm. But even any of the other fire department cases we've had. And there's a case called Shiano versus, Mr. Luce will tell you because he's the one that cited it. But it's very, very much on point to this case. And it was a person required to have a car, had a license plate with a fire department logo on it, everything else, drove out of the fire department lot and ran over somebody on a bicycle. Or a motorcycle, I can't remember which. But they discussed that, and they did not find that to be persuasive under the circumstances.
Counsel, turning to the question of insurance, can you point me to the section of the policy that extends the exclusion endorsement to the auto policy?
I can if I find my brief here. You mean our policy?
Yes.
Well, we had
your agreement.
We have two potential avenues of coverage for this, and you're talking about the sovereign immunity issue.
Yes.
Okay. We have two avenues of coverage. One was through a governmental liability coverage, which very clearly excludes activities relating to fire departments and firefighting. We glossed over that pretty much in our...
So how does that exclusion endorsement, though, carry over into your auto policy?
Well, it doesn't.
The auto portion, your auto coverage.
We have a separate auto policy.
Right.
And the separate auto policy contains a grant of coverage that covers certain people, which includes volunteers, only, however, if acting in, quote, an official capacity for a member. This is really important. The member here is not the fire department. The member is the city of Pierre. The city of Pierre obtains their equivalency of insurance coverage from a source different than the fire department. Fire department has insurance through Continental Western. City has insurance through the Public Assurance Alliance. And in the exclusion, in the auto endorsement for the city of Pierre, it will cover a volunteer or employee, but only acting in an official capacity for a member. He wasn't acting for the city of Pierre at all. And he was not acting in any official capacity. And I think it's clear that you have to distinguish between official capacity and regular duties that might create a respondeat superior claim. You can look at SDCL 20-9-45, which is the statute conferring immunity on fire. That's not what we rely on here, by the way. But it's similar, and it says that you're immune as a fireman responding to a fire if you're performing an official, if you're acting in an official function or performing your duty. Now that was a paraphrase, but they use official function and duty separately. So our position on the coverage and the sovereign immunity is there is no coverage for this act. Therefore, the city as a governmental entity is immune.
And your time has expired, Mr.
Did that respond to your question? I didn't point to the
I have a
section.
few more, but that's okay. Thank you very
Thanks.
much. Yes, it did respond.
Thank you, Mr. Anderson. Mr. Luce, you have 10 minutes, sir.
May it please the court. I want to devote my time to the fundamental principle of sovereign immunity. But in response to some of the questions, first of all, Rob passed the torch on the Fiano case. A case out of Connecticut is uniquely similar to this case in applying the coming and going rule. License plate, had equipment in the car, going to monitor the radio at the fire station. He was coming. That was not an exception to the coming and going rule. And the other thing is we've heard today, and questions have been asked by Justice Jensen about the required vehicle. It wasn't a required vehicle. It wasn't a specific vehicle that was required. It was to get to the station. He could drive any car, but obviously a volunteer fireman, especially if he's going to a fire, has to be able to get there, just like any of us have to. When I first started as a lawyer, I have to be able to go travel for depositions. The employer didn't tell me I had to drive a 65 Ford that I might have owned. You just have to have a vehicle available. To go to this meeting, he just had to get there. That is not a vehicle exception to the strongly established coming and going rule that has been recognized in the restatement and has been the established law not only in South Dakota but elsewhere. Let me talk about sovereign immunity. There's no question that one of the fundamental principles of this state and every state is the government has immunity. The state and the state agencies, including municipalities and departments of municipalities, such as the Pierre Volunteer Fire Department, it is absolute. There is that immunity. There's no exception to that here other than there was insurance. The law has been established by our legislature that we are not going to give up sovereign immunity only under limited circumstances. Both SDCL 213216 and 2132A1 both establish two components to the purchase of insurance. One, you have to purchase it, and two, to the extent that coverage is provided under that policy. That's the second requirement. Because fundamentally, if a governmental agency does not have to waive sovereign immunity and purchase insurance, they can select to do that. They can also select the extent of the coverage. If they want to try to find a policy that excludes everything, if they could find one and afford it, I guess they could do that. But the two requirements, both under the Constitution and the legislative changes to sovereign immunity, is there has to be one, the purchase of insurance, and there has to be coverage under that policy. And in this case, it is established and undisputed that the policy afforded by Continental Western to the Pierre Volunteer Fire Department did not provide coverage. Mr. Hughes mentioned there was a property damage deal that covered, in this case, Mr. Tronvold's $1,000 deductible. We have to be careful about generalizations, either about traveling to a fire versus going to the workstation, as well as insurance coverage. There was a multiple different types of coverage under that policy. There was a provision for such things as cyber threats, terrorism, inland marine, excess, umbrella, business auto, general liability. All these and you have to look at the terminology for each of those different insurance coverages. The general liability did not apply because it specifically says it does not cover injuries arising out of the use of an auto. So the policy provision to look at is the auto policy, and that says clearly and without dispute, any employee of yours, while using a covered auto you do not own, but only for an official emergency response. That's the extent of the coverage. It is undisputed in here, Statement of the Undisputed Material Facts 44, that it was not an emergency. In fact, it was undisputed in Statement of Material Fact 45 by plaintiff JURGENS that there is no liability insurance provided for this accident. How do we need to go any further than that?
Can you, I think, so under the Continental policy, it uses the term official duty, and that was the property damage coverage that was provided. Can you, and Mr. Anderson talked about this a little bit, but explain using the concrete examples then, in the volunteer fireman, what's the difference between an official duty and official capacity?
Thank you, Justice. It is different. The exclusion's different. It's not an emergency like there is under the auto liability. For that property damage, it says the employee's vehicle can be covered under three possibilities: en route, during, or returning from official duty. Once he gets to the station, if he would have knocked somebody over at some visitor at the station, he's on duty there. So that part, during, would be covered. But he wasn't during. It was en route. So there was coverage under that because it did not have the emergency requirement like the liability policy. We have to look at the different coverages, and they have different applications. The one applicable here required an emergency, which is undisputed. And so there's no coverage under the specific portion of the policy that covers a liability claim. And furthermore, they had the specific South Dakota mandatory endorsement that said there's no waiver of sovereign immunity by the purchase of this policy.
Plaintiffs argue that's violative of public policy. I'd like to hear your response.
That argument's been made, but not a single case has been cited for that. Public policy is this state has sovereign immunity. There's no cases that have been cited that are controlling or persuasive to suggest that there's a public policy exception to limitations on insurance coverage. In fact, this court, which I would consider as controlling authority, recognized that in Truman versus Giese. That was a people fund case, but there was a specific exclusion, and the court upheld it, as it should. We cited Missouri cases and Idaho cases. They're all in the brief. They're all established that an exclusion on sovereign immunity, exclusion saying sovereign immunity is not waived, is permissible in that policy because, again, the governmental agency can decide if they even want to buy an insurance policy, and they can decide the extent of it. That's what the statutes say. It's not against public policy to adhere to the statutes.
Counsel, with respect to your statutory immunity claim,
Pardon?
With respect to your statutory immunity claim under 20-9-45, now Judge Trimble found that a question of fact remained regarding whether or not TRONVOLD's actions were not negligent or grossly negligent, and that should be a question for the jury. Did you file a notice of review on that question?
No, it did not, for two reasons. Thank you, Judge. Is one, because it really isn't applicable to this decision. It's a backup position, because that statute really requires you to be in the course of employment to have that fireman's immunity. Well, we think it's obvious that he was not in the course of immunity, so you don't have to get there. And secondly, as we cited in our brief, if there's authority to uphold the decision for any grounds, the court has the ability to do that. So I don't think it applies. But if it did, if the court would have ever said, yes, the coming and going rule doesn't apply here as an exception, and this is in the course of employment, then and only then would that statute have any discussion or applicability.
And that's an issue that we could reach on our own if we got to that point without you having raised it specifically.
I'm sorry.
No, and that's an issue that we could get to on our own if we were to get to that spot, notwithstanding the fact that there's not a notice of review on the issue.
Yeah, I think under those cases that say if there's any grounds for it, I don't think you have to address it. But if you did decide that, no, again, that coming and going rule doesn't apply, then you would say, well, even though we said that, frankly, the trial court's summary judgment should be granted because of now we apply 2945. But I think as Justice Gilbertson wrote in that Gabriel Bauman case, which is a different statute but the same type of deal, willful and wanton misconduct does not exist in this case.
Okay, thank you, counsel.
You're welcome.
Mr. High, you have 10 minutes for rebuttal, sir.
But 10 minutes goes fast. I got to get to insurance. I want to address one thing that I really think may be on the court's mind, and that is this sky is falling argument that the defendants keep making, that everyone's going to be liable if they get in an accident when they drive to work. Other states have done it. The sky hasn't fallen. They're still working. We're not asking that everybody who's driving to work who may incidentally use their car in the course of work be liable if they get into an accident on the way to work. We're asking for a very limited exception. First, there must be a requirement the employee use their own private vehicle in a significant portion of their job, which is the case here. There's control and there's benefit. We've talked about that. At a minimum, question of fact as to control and benefit.
I wanted to ask you about that. I know we're going fast, and I'll try not to take much of your time. But while I've got you here, I really want to understand your argument, because I'm looking at the case from the perspective of, hey, if we have to adjust the common law here, and that's your argument, to adjust it to allow an exception to the going and coming rule, what do we do then with this case? If it's a disputed issue of material fact, do we then just recognize, under your argument, that the exception could apply under general principles, but that applying the Rule 56 standard, we can't really determine as a matter of law whether there is an absence of disputed material facts and someone's entitled to judgment as a matter of law? So then what? The judge instructs the jury on the exception that you want us to adopt, and the jury does that part of it?
If you say there's no exception, I think the case is over. What we're saying is there should be an exception under certain specified and very limited circumstances. And yes, if you do get to that point, I think the court is going to have to lay out what factors the trial court will use in trying this case and what issues go to the jury and on these findings of fact. So one, for instance, I think what we're asking is that our limited request for the exception under this required vehicle exception is significant portion of the job. Employee must own their own vehicle. They must, at the time of the accident, they must be acting for the benefit of the employer. In this case, Mr. Tronvold was going to training with his personal protective equipment to learn how to be a fireman. He wasn't benefiting from this. The sole benefit to him, or the sole benefit in this case, was to the Pierre Volunteer Fire Department, because they were getting firemen who were volunteers better trained. In a normal employment situation, the person goes to work and he gets paid, so there's that mutual benefit when that starts. And third, under this narrow exception, and this may be the most important part, that this isn't going to expand the common law beyond all expectation, is as a fireman, Tronvold was always on call. And so I think you can read into the exception we're asking is that, is the person on call? Is he going to have to take his vehicle at any moment and go respond to a fire? So this is a very narrow exception.
That's an important distinction, whether they're on call or not.
Because when your law clerk is driving to work, Your Honor, he's not going to get a call that says, hey, you need to run over to an emergency situation to do this or that. As a fireman, he has to have his vehicle with him. He has to have his personal protection equipment with him. And so the distinction is that at any time he can be called to a fire, to an emergency. And so that's not going to open up this to the entire course of every employee who's driving to work, because as he was driving to that meeting, he didn't, but he could have gotten a call that said he had to go to a fire. And if he wouldn't have been in his own car and he wouldn't have had his equipment with him, he wouldn't have been able to respond to the fire without first going home, getting that equipment and finding some transportation. So it's not the normal case. This is a limited exception we're asking for.
If the fire chief testified that he couldn't recall an instance where a firefighter had not had a vehicle in the past, and that he would expect that, just as a matter of experience and practicality, that he would expect that a firefighter would have his or her own vehicle. Is that a requirement?
Well, I do know this. We asked the question at the deposition of Ian Paul, the fire chief, is it required that a fireman have a vehicle? And he said yes. So I can only take what the fire chief says, and I think if we're getting down to that situation, I think it's at least a fact question. But I think we have overwhelming evidence that both from the fire chief's words that it was a requirement, and from the practicalities of the job, it is a requirement. If I could talk about insurance briefly, I want to just talk about, as Justice Kern asked, the city of Pierre has a governmental policy and they have an automobile policy. We don't care about the governmental policy. Throw it away. What the city did was, at the trial court level, they cited the administrative policy exception for firefighting activities. The trial court, we responded to it and we said, look, you're mixing up your policies. That same exception is not in the automobile policy. And the city never responded to that in the reply brief. It never came up at the argument, but the trial court, for some reason, thought it must still be there. But that was error. The fire department exception does not included in the automobile policy, which is the issue in this case. And furthermore, I want to cite the court to TAMMEN Appendix 99, where it lists who's covered. And clearly, the fire department is a commission, council, agency, district, authority, or board of the city, and its members are covered under this policy. So,
Respond to opposing counsel's argument that under that provision, it requires them to be acting in their official capacity, that what is the difference, if any, between official capacity and the official duty language that the fire department's policy paid the property damage? I understand they're two different policies.
I don't think there's any difference. I think it's a circular argument. If you find that he was not acting within the course and scope of his duty under the required vehicle exception, I think there's no coverage. If you find that he was, or there's a question of fact, there is coverage. Because if you find that he was within the scope of his duty, then he's acting in his official duty. At least that's how I read it, Your Honor. So I think clearly the city has coverage if you do find that there is the required vehicle exception applies, and it's set forth again in TAMMEN Appendix 99. With regard, and I think that coverage also covers the fire department, by the way, because the coverage says it covers the boards and its members, so it keeps the fire department as a defendant as well, even though it's under one policy. With regard to the Continental Western policy that the fire department purchased, all I can say is this. The Pure Volunteer Fire Department, using city funds, thousands of dollars of city funds, bought a liability policy to protect the citizens of Pure, to protect the traveling public, and at the very end of this liability policy, they put an endorsement that says nothing in this policy should be construed to eliminate sovereign immunity. And so the Pure Volunteer Fire Department is taking the position that we have insurance, we paid thousands of dollars for it, and yet we're going to claim sovereign immunity because at the very end of this policy it says it doesn't exclude sovereign immunity. That makes no logical sense, and that's why we've argued it's against public policy. You can't buy an insurance policy to say you're protecting the citizens of Pure, or whoever happens to be in Pure, and then at the very end of the policy...
Well, they may be able to buy an insurance policy, but do they have the authority to waive sovereign immunity, which is in effect what the policy is purporting to do? Doesn't the legislature have to do that?
Well, I don't believe the legislature contemplated when they wrote this statute, and there's nothing in the statute that suggests, hey, you can buy insurance and then you can waive it. I'm quite frankly not even sure why they buy liability insurance if they're going to say on the end.
Well, that's really the argument, right? The optics are that they made a bad bargain because they didn't really buy anything with their premium.
Exactly. If I accomplish nothing more from driving down here today, I want the citizens of Pure to know that when a fire truck's coming down the street, they better get as far out of the way as they can, because the city of Pure is going to say, we don't have insurance because we bought a policy that at the very end says, oh, by the way, we don't cover anything. That's why it's against public policy. But if that's
the case, how does that necessarily benefit your clients? I mean, it may have been a bad bargain if you pursue that argument out there further, but that doesn't necessarily mean that it didn't do what it purported to do, which was go no further than waive sovereign immunity, no further than the law permits.
You make a good point. I guess our argument is you shouldn't be allowed to do it. As an insurance company, you shouldn't be allowed to do it. As the volunteer fire department, you shouldn't be allowed to portray to the public that we have coverage that protects you. And then at the end say, oh, but if you read the fine print, we don't. That's the violation of public policy. So, I guess in conclusion, I mean, I think this exception should be recognized. It's very limited. It's not going to change the world. It's going to create justice, and that's ultimately what we're here for, is justice. We're here for justice for these people who lost their legs in this tragic accident. We have the benefit and control issues that we look for when you look deep down and you try to rationalize why do we make the rules we make. We make them, in this case, sovereign immunity, for benefit and control.
Your time has expired, counsel. Thank you. The court will be in recess for 10 minutes.